appeal in the matter of Qatar Investments and Project Holding Co. and another, and Phoenix Ancient Art S.A.
Yes, Mr. Stewart.
My lords, my lady, I appear in this matter with Mr. Harris, my learned friends Mr. Cooper and Miss Mitchell appear for the respondent.
Yes.
My lord, Mr. Alan Turing might quite like this case. I can express my submissions in 1 word and 7 numbers. The word is COVID. The first number is 19, which probably requires no explanation. The next 6 numbers are 182, which is the number of days which we had to serve the claim form out of the jurisdiction in time abroad, from the 22nd of January to the 22nd of July. The next number is 47, which is the days late we were in servicing, or more accurately, the number of days outside that 6-month period, that being from the 22nd of July to the 8th of September. The third number is 56, which is from January the 22nd until the 16th of March of 2020. Those are the days which were unaffected by lockdown. The 16th of March is taken from Mr. Baker's witness statement. There is a detailed chronology, those of us who don't have it imprinted on our memory, of the events, including those of March of 2020, at page 50 of the core bundle. And what they show is the rapid transition from herd immunity through to working at home and lockdown, and it is fair to say that full lockdown comes in on the 24th of March of 2020. The significance, of course, of that 56 days is that those were the days within the period concerned which were unaffected by COVID. In other words, we had 56 of the 182 days which were unaffected by COVID. The fourth number is 84, which is the period of time between January the 22nd and the 15th of April. The 15th of April is the day when the Foreign Process Service was suspended, and that was suspended until the 28th of July. It follows that unless we had served before the 15th of April, there was no prospect of serving these defendants who refused to accept service voluntarily out of the jurisdiction in Switzerland. So it follows that we only had 84 of the 182 days, in other words, less than half the period permitted by the rules, within which it was actually possible to serve, regardless of the difficulties caused by lockdown and so forth, between the middle of March and the 15th of April. The fifth number is 28, which is the time it actually took from when all documents, which included, of course, not merely the original claim form, but also the translations of the certificates extending time, and indeed the particulars of claim, were given to the FPS on the 11th of August and served on the 8th of September. In other words, from the time after the FPS resumed until service was only 28 days. The last is 23, which is the number of days between when the translated documents would have been ready for service, but for the need for an extension, which is the 29th of June, and the 22nd of July, which was the date when absent an extension of time of the claim form, time for service expired. Now, the reason for running through those dates...
Mr. Stewart, I'm very sorry to interrupt, and I'm very sorry to be dim. You started with a number 19.
COVID-19, my lord.
Oh, I see. Sorry. I thought it was, because I thought all these others were days, I thought those were days too. So I apologise.
It was a moment of what was intended to be an appropriate levity, by the way.
Well, I'm all for that, but as I said, being too dim, I didn't understand it, so I was trying to work out where the 19 days fitted in.
You could ignore 19.
Well, while my lord is recovering, can I ask you for another couple of figures, which is firstly the number of minutes that you're going to be on your feet, secondly the number of minutes that Mr. Cooper will be on his feet, and thirdly how long you want for your reply.
The first is, I hope, less than 30. I guarantee less than 40. I can't answer the second directly because it's not within my control.
It won't be any longer than you get. So.
And the third is no more than 10, and I hope nil.
Well, I just wanted reassurance that we're well within our allotted time.
We are well within our allotted time, my lord.
Thank you.
What are the consequences of those numbers in terms of the submissions I make? The first is that there is one complete certainty in this case, and that is that unless service was effected by the 15th of April, an extension of time would have been required. In other words, unless service had been effected within the first 84 days, less than 3 months, we would have required an extension of time because the FPS was suspended and because the defendants, as they were entitled to do, chose, despite being sent the claim form or actually their solicitors, not to take any steps in relation to it. The consequence of that is this, that unless service had been effected by the 15th of April, these defendants would not have received service of the claim form within time, and moreover, they would not in all likelihood have got it any time, certainly any material time, earlier than they did on the 8th of September, which was, as I say, only 28 days beyond the 6 months which was allowed. The second, we're now not dealing in certainties, we're dealing in likelihoods, is that unless service was effected by the 16th of March, it is extremely unlikely that service would have been effected within the 6 months. The significance of the 16th of March is that is the date of the commencement of real problems in relation not just to COVID generally, but specifically in relation to the court service. And we've identified on page 50 in the chronology the matters, the Lord Chief Justice's remarks, the fact that the counters were closed, the references to there being difficulties with service and so on and so forth. So we say the substantial likelihood is that unless one had served by then, we would not have made service within the 6 months. The third submission, again in terms of likelihood, is that but for COVID, the likelihood is that service would have been effected in time. And can I just put the building blocks of that together? The first is that the documents actually were ready for service, which needed to be served by the 29th of June, other than the extension of time which required to be translated. And what happened then is that advice was sought from the FPS as to whether or not everything should be served at once, or we should serve the certificate later, and they said you should serve everything at once. That not being surprising, given that the service was still suspended until the 28th of July after the period. It therefore follows that 23 days before the 22nd of July, the relevant documents were ready for service. The actual period of service took 28 days. So speeding up the process by 5 days, the likelihood is that service would have been in time.
Didn't the FPS though say to you at the same time that that historically it was a 2-month service period for getting service in Switzerland, and sort of what appears to have happened is that once they reopened and they had your papers, in some form it looks as if they accelerated service in your case to 23 days, but that perhaps the yardstick, you might say, the court should be working on is that it was a 2-month service period. That was what the FPS said.
But my lady makes, if I may say so, a very fair point. They said that based on previous, I'm paraphrasing, but based on previous experience pre-COVID, service of documents usually took 2 months in Switzerland. My lady, I don't think there's any evidence of them having speeded up the process in this particular case. I accept, of course, that that would have been given in good faith. I'd also make the fairly obvious point that if you're giving out advice as to likely periods, you're likely to be conservative rather than the other way around. I hesitate to give evidence about the efficiency of the Swiss Postal Service, but I can say that having an address in Switzerland, it often is quicker to have things delivered there than it is in England, but that's by the by. The point, however, is this. Even if you were to, as it were, take 2 months instead of my 23 days, you still get to an acceleration not of only 5 days, but of only 35 days in relation to the relevant period to get service likely to have been effected in time. The next building block...
Are you moving away from your consequences building block?
No, I'm still on the building block of the likelihood of service having been effected in time.
Right, this is your third consequence.
Yes, this is my third consequence. Sorry, I'm still within the sub-block building blocks of consequence. The next building block is this. The events of March, particularly, and April 2000 have been judicially described on several different occasions in slightly different ways, but as being effectively the greatest peacetime dislocation to normal business, certainly in the living memory of those of us practicing now. Peacetime is perhaps, in the light of present events, an appropriate qualification, but subject to that, in my submission, it is not hyperbole to say that everything was dislocated in March. There is actually evidence about it, but your lordships and your ladyship may think that it's not actually necessary to have evidence. People were required by statute, or actually statutory instrument, to work from home. Schools were stopped. Those with school-aged children had to look after them at home. Normal methods of communication and so forth were dislocated by communication, I mean internal servers, emails, access, and so on and so forth. All of that was happening precisely at the time when we're looking at. This isn't a case, as one of the cases is, which my learned friend refers to, Mr. Justice Butcher, of looking at events a year later, by which time people had become used to the effects of COVID and how they were. It was at the precise time when life was changing. In those circumstances, in my submission, in circumstances where you would normally be expecting competent solicitors to get on with matters, it is not at all difficult to accept that the likelihood is that there were delays caused by COVID. That's without reference to the specific evidence, which I shall be coming back to. Putting it at its lowest, this is still within 3, but putting it slightly differently, one has lost the certainty of being unable to, one compares the certainty of being unable to serve post the 15th of April with the loss of a very substantial chance of being able to serve within time, absent COVID. The last consequence is that it is most unlikely that effective service would have taken place, even if steps had been taken as soon as reasonably practicable post the 22nd of January. And just running through what the steps would be required in terms of post the 22nd of January, in my submission, the first and obvious thing to do would be to ask the defendant solicitors who'd been acting in another matter whether they were prepared to accept service. Indeed, one would anticipate being strongly criticised if you didn't ask to do that. So that is going to take some time. We know subsequently that in May they didn't answer, so sending a chaser is perfectly reasonable. At the same time, it is perfectly reasonable to get counsel to be drafting the particulars of claim. It is also, in my submission, obvious that you need to get the documents translated for the foreign process servants. Now, accepting, of course, that French is not the most difficult language to translate documents into, nonetheless, you have only got from the 22nd of January until either the 16th of March or the 15th of April to do all of that. And what you then do not know is what happens when you put it into the FPS, but you get the dislocation of COVID. The evidence is obviously complete suspension, but there's also evidence, unsurprisingly, of dislocation with the Swiss Postal Service at the point of dislocation. So in my submission, when one looks at the material facts in relation to this matter, it is fair to say that with COVID, there was an extremely small prospect of service being within the 6 months. Without COVID, there is a very strong likelihood that there would have been service within 6 months. I, of course, cannot tell your lordships or your ladyship that it is certain that we would have served within 6 months. But that, in my submission, is the appropriate balance. Against that background, can I go to the central criticisms that I make both of the master's judgment and of the judge's judgment? The reason for starting with the master's judgment is that the judge is effectively accepted that the discretion exercised by the master was reasonable, and therefore, amongst other things, declined to exercise.
Well, we're concerned with the master's exercise.
Sorry?
We're concerned with the master's exercise of discretion. The judge didn't remake the decision. And before you do this, and take us to the evidence, I want to ask you for a preview. In certain matters, the pandemic led to rules being changed. One can think, for example, of the suspension of possession of residential properties during this time. So there is an instance in which rules have been changed. You've given us 4 potential consequences. One you say a certainty, the others you say strong likelihoods. To what extent are any of those matters specific to this case? To what extent, in fact, is this not a plea for a general relaxation? Because it's not apparent to me so far how any of those consequences hang on the facts of this particular case. It would, if it doesn't hang on the facts of the particular case, then in effect what you're asking for is a general relaxation, which would apply to anybody, however hard they tried, or however lax they had been. So, which of these 4 matters couldn't apply to every civil litigant?
Well, my lord, I respectfully suggest that none of them. Can I answer your lordship's question in 3 parts? The first is directly to answer your lordship's question. None of them are directly equivalent to another situation, because we have got here a coincidence between a period of time, as it were, before the pandemic, a period of time affected by the pandemic, and so forth, and the dates which I've given you.
Yeah, well, I understand. Obviously, we're not talking about people in 1975, or we're talking about people in this time period. But there will have been people who were thinking of suing, who were getting on with suing, who were starting proceedings before COVID became apparent. to what extent is your client in any different position from any of those other putative litigants?
Well, my lord, the answer to that is that what I've sought to do by the 6 dates is to identify the specific correlation between actual physical effects and the consequences of the pandemic. Could I give your lordship my second and third answers, and then, as it were, deal with any follow-ups, only because otherwise I'm likely to wish in that I'd said something second. Secondly, so far as no general relaxation is concerned, that is of course true, although you will see, and it's set out, for example, in the passage from His Honour Judge Eyre's decision, which is at tab 8 of the bundle, that there was a practice direction issued, and that was directly issued in March of 2020, the relevant paragraph of which is at paragraph 17 of tab 8, which said, insofar as compatible with the proper administration of justice, the court will take into account the impact of the COVID-19 pandemic when considering applications for the extension of time for compliance with directions, the adjournment of hearings, and the application for relief from sanctions. So although it is true to say that there wasn't, for example, a general suspension of time for service of the writs, of the sort that your lordship was drawing, but may have been drawing by analogy with suspension of rent and so forth, there is nonetheless recognition of COVID-19 on a general scale. And the third point that I would make, my lord, in answer to your question, is that I do say that there is a general point of application, which is how you go about treating COVID-19 in the light of fact-specific circumstances. And the point I would particularly rely on is that where you have a massive dislocation to business, which is unparalleled in peacetime, it would not be surprising if that had, as it were, consequences for other cases. What I'm not seeking to do is tell your lordship that there is any general departure from the terms of the rules put out.
Okay. For my information, have there been any COVID procedural cases in this court as opposed to the other cases that you've collectively gathered together?
My lord, both my learned friends and I have undertaken searches for such guidance as is as is apparent. We have none of us found anything from this court which is of assistance, because the purpose, frankly, of the supplemental skeleton was to do a search for anything which might be of assistance. I know this court doesn't like a plethora of authority, but we did anticipate it being said.
The question was not so much just to make sure that we are not unaware of something that's been,
well,
been
we
touched
have certainly
already.
looked for that. If we haven't found it, it's through negligence, but we are not aware of anything.
Right, thank you.
My lord, I was dealing with what I was going to say about the judge's or the master's judgment. Could we go to the master's judgment, which is in the core bundle at paragraph at tab 12? I want to draw your attention very briefly to what is said at paragraph 12, and then in particular to what I say are the key passages in his judgment which I criticise at 14 and 21. Paragraph 12, the judge says, standing back from this, did the claimants take all reasonable steps to comply with the rules such as to establish good reason not to have served the defendants by the 22nd of July? Much of the claimants' accounts of what they did and when they did it, which has been set out with great care, is not difficult to relate to or to have considerable sympathy with. Nevertheless, the conclusion in line with the authorities dealing with the extension of time, etc., needs to be arrived at. And then paragraph 14, the impact of the public health emergency, which has characterised so much of life since it came upon us in the spring of last year, has been emphasised. To my mind, the upheaval, the great uncertainty that came with it, ultimately meant more risk, not less, was to be accepted. in the circumstances, it would have been a wiser course to leave even less to chance than might otherwise be possible in circumstances known before this. Individual calculations and judgments in litigation of this sort would inevitably count for more in less certain and less predictable circumstances such as these. So what does that mean? Well, it can only, in my submission, mean one of two things. Either that before the 16th of March or thereabouts, somehow we ought to have anticipated the public health pandemic and taken steps to effect service earlier than the 16th of March. Now, if that is what is being said, it is, with respect to the learned master, nonsensical. The chronology which we have set out demonstrates just how quickly the pandemic came upon us. Although it is, of course, true that there were reports of the pandemic in Wuhan and so forth, and no doubt with the great benefit of hindsight it being a wonderful thing, it can be said that steps ought to have been taken during the course of February and January and so forth to protect us all from the public emergency. The idea that a solicitor should have taken steps before the middle of March to take account of that is, in my submission, unrealistic.
This is a paragraph which comes in the course of the judge, the master, giving a list of principal factors that he was holding in mind in reaching his decision.
I should
And
perhaps.
I think it's the third of the five that he mentions.
He does. Well, the reason perhaps I should have taken it to you first. The reason I took it particularly of importance is paragraph 21. If your lordship would be kind enough to look at 21. The fact is that the claimant's representative chose, by their own candid admission, to make no use of the reduced time that was available following the issue of the claim, and this in circumstances where, by any reckoning, there was very good reasons for them to progress the claim as quickly as perfectly as possible, bearing in mind that the claim had been issued on leave of imitation. Well, bearing in mind what is said in paragraph 14, that which appears to be a conclusory paragraph is saying you ought to have taken account of the reduced time that was available to you. The reduced time, reading the judgment fairly as a whole, can only be that prior to the pandemic, and that therefore must be the master concluding that prior to the pandemic we ought to have anticipated it. The only other reading, in fairness to the master, is this. Once the pandemic comes upon the world and us in March of 2020, we ought then to have taken immediate steps. Well, there are two problems with that. The first is that it is, with respect, unfair to suppose that at a time of great dislocation, not just to us but to everyone, we should take enhanced steps to try and achieve service. The second is that in any event, the taking of such steps would have done no good whatsoever. There is no prospect of taking steps by the middle of March which are going to cause service to be affected by the middle of April.
Why do you say that solicitors in this position, once everybody was engulfed by this problem, who had this claim that, as it were, was going to go off if it didn't get served in time, why do you say that it's unfair to have expected people to have, as you put it, taken enhanced steps to combat the difficulties?
Well, because it ignores the dislocation which is bound to be taking place.
Yes, but there's no evidence of that in this case.
Well,
I mean, there's beyond the generalities that everybody was having to deal with this. We don't have any evidence that.
I was going to come to the evidence of that. Can I make my submissions in relation to that?
Well, just at the moment, I mean, because you've put a stepping stone in your argument, which is that if the master is not saying that you only had the time before the pandemic, and you were to interpret it as saying that once you knew about the pandemic, you had to get on with it. Why is it unfair for him to have said you had to get on with it once the situation had arisen?
Well, I accept, my lord, that there is something of a value judgment, but in my submission it is utterly unrealistic against the background of what else is happening. I mean, it would be the equivalent of saying to judges, why on earth didn't you immediately get the juries into court and take enhanced steps to do it? It is ignoring the obvious effects of enormous dislocation on individuals and people. On the evidence point, my lord, can I briefly make some submissions about evidence? Because as your lordship anticipates, I haven't got to it yet.
No.
Because Mr. Pulford's third witness statement.
Well, my mind is open. I'm just saying that it hasn't been like one of those cases where you said, well, we had this terrible situation where, for example, the person who was in charge of the file became seriously ill, because we had a particular event in relation to our management or our systems or something of that sort. Everybody was working around.
Can I address the matter generally? I will take you very briefly to Mr. Pulford's third witness statement. I do want to make it plain that Mr. Pulford's third witness statement was before the judge, but not before the master, as you understand. But can I just make the generalities plain?
Yes.
One is considering, in relation to the evidence of the sort your lordship is looking at, evidence as to a hypothetical situation. Evidence as to a hypothetical situation from a witness of fact is admissible. There's authority to that effect, both in the medical and indeed in other professional contexts. In other words, but for this medical treatment or the failure to warn, what would I have done? That sort of evidence. Although it is, of course, opinion evidence, there is authority for the proposition that provided it is given from someone with personal knowledge of the facts and circumstances, it is admissible. So I don't say that such evidence is inadmissible. However, the courts rightly treat such evidence with considerable hesitation, because of necessity it is not saying on the 15th of March I did X or Y. It is saying on the 15th of March in a different hypothetical situation I surmise that I would have done X or Y. When looking at such evidence, the courts are rightly particularly careful to say that you have to check that evidence against the inherent probabilities and, insofar as it is available, any other indications which are there. When one looks at the inherent likelihoods, what one is saying is, well, would one have allowed a significant gap to occur in relation to a claim in ordinary circumstances? Or is it credible that the process would have been accelerated in ways which are now difficult to estimate, but which are nonetheless real, and which are reflected in the general concern and in the practice direction? Now, this court, and indeed judges in general, have been extremely careful to warn of the dangers of witness statements whereby witnesses over-remember what they have done, and they reconstruct, and so on and so forth. Where, therefore, one is really dealing with a hypothetical situation, to criticise, as the judge does when we'll get to it, the evidence which was before him as being effectively insufficient has a degree of, there is the danger of double standards being applied. Because it is not a case where honest witnesses are likely to be definite. I accept, of course, your lordship's general point that if it could be said that the particular fee owner concerned was ill and so forth, you'd expect to have evidence of that. But that doesn't mean that there isn't dislocation and so forth on a more general scale. Lord, I was criticising the master's judgment. I'm conscious of my self-imposed time limits and more honestly.
Don't worry.
The paragraph 14, I've really given the two alternatives. I accept, of course, that if you look at you have to read the master's judgment as a whole, as I'm sure this court has. the factors which are there set out in my submission are all taken into account. But the third factor, the one we were looking at, is a key one. And one can see that it's key by paragraph 21. And I maintain the submission, which I think I've already made, but if I haven't, I'll make it, which is that standing back from it, what good would that have done? Acting more quickly from the middle of March might have shown that we were keener to get on with it. It wouldn't have done any good so far as this defendant was concerned. It wouldn't have got the action served any quicker and so on because of the effects of COVID. So to use language which at least one member of this court is likely to be familiar with, the dominant cause of the delay which occurring in my submission can fairly be said to be COVID. It's affecting the actual process of service, the foreign process service. It's affecting the solicitors who are trying to carry out work in relation to it. It's probably affecting the defendants as well. Well, that's my essential criticisms of the Master's judgment. I say with respect to the judge that the difficulties with dealing with the passage which I've just identified are shown by the judge's judgment. If your lordships would go to the judge's judgment, it's at tab 7. The critical paragraphs of are at paragraphs 42 and following. And 42 is on the bottom of page 69. I don't want to be said I haven't read everything relevant, but could your lordship just cast your eye through the beginning of 42? I want to pick it up over the page at page 70. Where towards the top right of the first line, it's necessary to emphasise that the rule permits 6 months to serve out of the jurisdiction, not the better part of 6 months before taking any steps to discover what needs to be done to serve out of the jurisdiction. Reasonable steps in the context of this case would have involved the claimants at an early stage informing themselves of the processes by which service out of the jurisdiction would be effected. Had they done so, the problems with the FPS, about which they knew nothing at all until late June 2020, could have been overcome. Well, that is an extremely difficult sentence to understand. Let's suppose that on the 23rd of January, my solicitors had taken steps to find out that it took 6 months, the steps which would be necessary for the foreign process service and so forth. The only way that could have led to, as it were, service in time, was to then, thinking not that they had 6 months, but that they only had either just under 2 months, or at most just under 3 months, until the middle of March or the middle of April. In other words, they would say, we have to immediately get this translated, get it issued, and so forth. And that is giving the claimant not the 6 months, which is afforded by the rules, but is actually less than 3 months. Unless it said that they should have anticipated the pandemic, which is the very feature that I was criticising the Master for, and which the judge had already indicated that this wasn't the easiest passage to understand. And if you see that, paragraph 43, the paragraph of the judgment dealing with the effects of the pandemic is not the easiest part of the judgment to understand. However, the Master was entitled to observe that the pandemic did not come wholly out of the blue. It was something in the general public consciousness by early March 2020. As I've indicated, a critical factor in the Master's reasoning was the total lack of activity between the 22nd of January and the 5th of May. It was not illogical for him to refer to the need to leave nothing to chance, given what was unfolding from early March. In fact, by doing nothing for another 2 months, the claimants did take a risk. Well, that nowhere acknowledges two things. The first is the obvious problems which are occurring, amongst other things, for the claimant solicitors, the points I've already made. And the second is that taking more steps then would have not have done the blindest bit of good. Because it was no way that you were going to serve within time. The only way, by the beginning of March, that you were going to get this served in time was if the defendants chose to accept service when it was sent to them in May. They were entitled not to do so, but that was the only way you were going to get service done in time. And so, with respect, the judge's judgment illustrates the fundamental difficulty with the master's reasoning. Now, I accept, of course.
Help me with what happens in these cases. You issue a claim form, and the claim is against a foreign entity, and so you've got 6 months from the time of the issue.
Sorry to interrupt you, Marty. You do not automatically have 6 months. It depends upon the form in which you issue the writ. It's either got to be issued for service in or service out. Right. You have to, as it were, show that it's service out. So, for example, if someone who's outside the jurisdiction is prepared to accept service within, either on himself or another entity and so forth, then you can serve it in the ordinary form within the 4 months. If, however, you have to go outside, because you have to serve outside, then you have to endorse the form of the claim form as being for foreign service.
Well, I take that point, but from the perspective of the claimant, they have the prospect of having to serve outside the jurisdiction is known to them from day one.
Unless there's already an agreement in force, that's correct.
Yes. They may be able to do it more easily if service within is acceptable to the...
I mean, there are obvious, sorry, I didn't mean to interrupt. There are obvious some other alternatives. For example, yes, you can go to the court getting an order for substituted service if someone's been... But subject to all of that, yes.
So is it not reasonable for the court to say, well, what were you doing in the first couple of months?
I agree.
Why were you not getting all these documents translated? Why were you not making inquiries about service and so forth? Does that not form part of the picture in deciding that when things went badly wrong later, opportunities had been missed earlier? Must that not be part of the calculation?
My Lord, I cannot say that it is an unreasonable judicial observation to say, well, you should have found out about service on the 23rd of January. I do maintain the submission. So what? Because for the reasons I've already identified, it is plainly, my submission, reasonable. Indeed, given the overriding objection and so forth, anyone who knew that there were solicitors who were acting in allied proceedings, who didn't write to them saying, are you prepared to do it so as to save costs, would be rightly subject to considerable judicial criticism. You'd never get the costs of doing that if you hadn't written to the other side solicitors saying, will you accept it and so forth. I'd also make the observation, my Lord, that although, of course, the authorities are replete with observations along the lines, if you leave things to the last minute and so forth, 6 months does give a margin of appreciation. When, dare I say it, and I suspect your Lordship started in practice, one had 12 months in which to serve an ordinary writ. That was cut down to 4 months. The fact that you serve overseas gives you another 2 months. There are some jurisdictions, for example the UAE, where I understand the usual position is that there is no chance of serving in the UAE within 6 months, so masters habitually give extensions of time because of that, because of the effectual evidence. Here, as my lady said, the apparent evidence is that the usual period is 2 months or thereabout. Well, it is a counsel of perfection to say that in circumstances where you've got 4 months for an ordinary writ, you do everything on day one, point one. Point two, there is evidence to the effect that they were getting the particulars of claim drafted. Perfectly sensible thing to do in circumstances such as this. And point three, which in my submission is of considerable importance, even if we'd done all that, by the time we'd written and so forth, if you look at the timescale, what are the real prospects of getting this done before before March, for causation reasons I've already put forward.
Mr. Stewart, can I just come in and ask you this? It seemed to me that it might be said that there was a finding against you by the Master that there had been a lack of activity between the 22nd of January and the 5th of May. And
Yes.
we can argue about whether that goes on through May and into June or not, but let's just take it there. And that's really, in a sense, something you've got to live with. Isn't really the essence of your cases, and this is perhaps the point for us, that doesn't matter because we wouldn't have got there anyway. So it doesn't matter that we sat on our hands for 3.5 months because, in fact, unbeknownst to us, we were already scuppered by what was going on at the FPS.
There's two answers to that, my lady. One, yes, I agree. But two, secondly, this is not a situation where the, as it were, as happened position can be assumed to be independent of COVID. Now, plainly, it's independent of COVID until the middle of March, because on my submissions I've said that it's come out of a blue. But the relevant period is not, in my submission, the 22nd of January until the 5th of May. It's the 22nd of January until the 16th of March, hence...
But that's the point, isn't it? You say that's the period we should be looking at, because on the 16th of March, in fact, unbeknownst to you, things happened that would have scuppered you, because that's when, well, COVID happened.
We knew about COVID, and we knew the effect on us of COVID.
You didn't know about the FPS effect, did you? And so that whatever you did, however hard you ran after the 16th of March, you say we're quite likely to have missed the deadline anyway.
Quite. Yes,
and that's the real point of
point.
the appeal, in my view. I understand what you say about the general points about COVID, but the real point is the so what point. The dominant cause, even if in fact it was something you didn't know about. I've got your submission right. You say that doesn't matter. You can rely on it because it was an existing state of fact, even if in fact it wasn't a reason, or at least didn't become a reason for a long time in this case, because you didn't know about it, but you say that doesn't matter.
Yes, can I answer, try and give the same answer to your lordship as I gave to my lady. There are two in the facts which occurred, the Master criticised us for doing nothing, effectively, between the 22nd of January and the 5th of May.
Yes.
One, you cannot assume that would have been the same position absent COVID. Not because we knew about the FPS, we didn't. That's not our evidence. But because of the general dislocation, which we do give evidence about. I think I need to take you to this.
At some point I'm going to need to be satisfied.
Yeah, that's the general dislocation point.
That's the general dislocation point.
But if you're wrong about that, let's assume you're wrong about that point goes, then...
Well, my lord, the harshest that the point could be put against me is this, that you can be satisfied on the material before you that COVID made no difference to us until the 5th of May of 2020. In those circumstances, you would then say, right, well, does that therefore mean that although from the 5th of May service was plainly impossible, discretion should be exercised against the defendant because of that finding? Yeah. In my submission, the answer to that would still be no. First, because even from the 5th of May, we've lost the chance of serving within time. By the 5th of May, the FPS is shut until the 28th of July, 6 days after the relevant period is expired. Secondly, the causative effect of the lack of knowledge is non-existent. And if you are standing back and even looking at all the authorities, you have to look at causative effect as well as, it were, moral blameworthiness. So far as these defendants are concerned, unless they're served by the middle of March, or unless they accept service voluntarily, they're not going to be served with this claim any earlier than they in fact were, the 8th of September. So what are you doing by deciding to exercise your discretion against the application? You're punishing the claimant's solicitors for something of no causal relevance, which prevents a claim, otherwise a bona fide claim, from going forward when they actually knew about it, to no effect at all. That was going to be my peroration, so I won't give it to you again.
Well, I'm glad to have teased it out earlier, obviously.
But I do, because I'm conscious that that, as it were, is quite naked and quite stark, I do maintain the proposition that you're not, in fairness, comparing like with like, because there is inbuilt in that an assumption that you can assume that we would have done the same as we did between the 22nd of January and the 5th of May, as we in fact did, because of what actually occurred, despite the fact that COVID had been going on.
No, I understand how you put that, but getting through to the kernel of it, I think that is the kernel of your appeal, is the point you just made.
Well, my Lord, I've already said that
in my preliminary view,
your Lordship is ultimately one of the three people who decide whether it's the Colonel or not. I would like to persuade your Lordship that it is one of the two Colonels.
I understand that.
Can I go with that, please, to Mr. Pulford's third witness statement? Because perhaps before we do that, we should just look very briefly just to see what the judge says about that, just to remind you, so that you can see the criticism. The criticism of Pulford 3 is at 46. Could I ask, rather than read it out, just that you read paragraph 46 on 70 and 71, so that you have the criticism in mind?
Sorry, what am I looking at?
Paragraph 70 and 71, my lady. Last two paragraphs of the judge's judgment, which deal with Pulford 3.
Pages 70, 71.
Ah, I was on paragraph.
Sorry,
Okay.
my fault. My fault.
So paragraphs what? Sorry.
Last two paragraphs of the
Thanks
judgment.
very much.
Sorry, paragraphs.
But this just help me, just orientate me, because Pulford 3 was put in before the judge but wasn't before the master.
Yes.
So you only get into Pulford 3 if you think the master went wrong.
I agree, which is why we've come to it at the end.
Yeah, and the judge didn't think master went wrong, so technically this is all very well, but it's obiter or whatever.
I agree, my lady. That is the logical thing. On the other hand, it does seem fair to the judge to show you the criticism before I say why it's wrong. Now, Pulford 3 is in the supplementary bundle for the appeal at tab 7. The relevant pages start on, sorry, the relevant paragraphs start on page 15.
Page number.
Page 15, my lord. Thank you.
Yes, what would you like us to read?
Well, can I just take you through it very quickly? I'm not going to read out any more than I have to, but can I take you through it quickly? Paragraph 8 is simply a list of dates of publicly available information as to what happened generally. I don't believe they're in dispute, but they show, as it were, the severity of the events, and they are within the chronology which is set out. Paragraph 9 deals with the fact that solicitors and the courts were under significant pressure. They refer to, for example, the Lord Chief Justice's statement on the 17th of March. And then paragraph 10 and following deal with the effects on Pinsent Masons. The government's warnings, and in particular the national lockdown with effect from the 26th of March, inevitably had a significant disruptive effect on Pinsent Masons' business, as it likely to have had on all UK businesses. Such directive effect impact was in addition to the direct impact of the FPS. A period of adjustment was necessarily required as fee earners and business support staff who were used to working collaboratively in a single London office and across St Mason's national offices were suddenly required to establish working from home practices, and those managing teams had at very short notice to introduce new supervision and team working arrangements. In addition, with all schools in the UK being closed from the 18th of March, the difficulties of the lockdown were compounded by homeschooling requirements and other similarly family issues. Consequently, during this time, normal case management and decision-making practices with respect to the service of the claim were disrupted. Tasks took longer, including for myself and my assistant at the time, Miss Natalie Melville. Whilst in retrospect it is difficult to precisely state or quantify what would have been done and when with respect to the service of the claim, but for the impact of COVID-19, notwithstanding other work-related pressures and commitments, I have a high degree of confidence that it were not for the effect of COVID-19, the two letters sent by St Mason's to Boys Turner on the 7th and 15th of May, in which Boys Turner were asked to confirm acceptance of service, would have been sent sooner. Had the letters been sent earlier and the same lack of response received, St Mason would have taken the requisite steps towards service of the claim out of the jurisdiction at an earlier date, including those steps outlined at paragraphs 14 to 20. Now, this evidence can fairly be criticised for not, or can be said, not criticised, that this evidence doesn't specifically say, well, I can definitely say that it was affected in this way. But this is evidence given by a senior solicitor, which in my submission is overwhelmingly likely to be true as to the general disruptive effects. He identifies the particular impact on the taking of decisions and so on. And it is right at the time when the first impact becomes apparent. In other words, one is dealing with the period on what we're looking at from the 16th of March to the 7th of May. Now, what I say with regard to that is that a solicitor who honestly says this, says high degree of confidence, but necessarily says that in a hypothetical world he can't be certain as to precisely what would have happened, is a solicitor who is like...
I don't understand why you say it was a hypothetical world. That it would surely have been open to him to have said what the situation actually was. That we had 1,002 cases, that we're having these difficulties. There were home care issues with one of my team or something of that sort. But it's not a hypothetical world.
With respect,
in a sense, what's being described here is what we did or what we didn't do, and if we didn't do it, why we didn't do it.
With respect, my Lord, it is a hypothetical world. What he's trying to tell your Lordship, we know when the letters were actually sent. What he's trying to tell your Lordship is what would have happened but for the impact...
Well, what he might have been trying to say, and if this wasn't what he was trying to say, is why we didn't get on with it. And that we weren't able to get on with it because COVID did this, that, and the other to us. But there's no specific evidence of that kind.
My Lord...
Which is the point I was making to you earlier.
No, my Lord, I accept it is. I'm quibbling, if I may, and I'm not sure that me carrying on quibbling is going to be of much effect, but I'm going to try once more. When one looks not at what did occur, I sent a letter on the 5th of May and so forth, but what would have occurred but for COVID, it is fair to describe that as being a hypothetical situation.
No, I mean, I just want to put a mark down that is overcomplicating the matter. That actually what you need in a situation of this sort is to say, we would have done this at such and such a time in the normal course of events, but we were prevented from doing it because of this, that, and the other factor. But simply say we were prevented from doing it by generic COVID considerations is what led me to say earlier on that there was no evidence of the effect that COVID had in fact had.
Can I give your Lordship an example which is not hypothetical? I'm currently sitting as an arbitrator between the Republic of Ukraine and some private entities. I received an email on the 25th of February saying that as a result of the Russian invasion, they were unable to work normally. I didn't require evidence as to exactly how it was that they were unable to work normally before taking the view that a suspension of the arbitration would be appropriate. There are some events which give rise to disruption of a sort.
I follow that, but that, to my mind, underpins the point that's being made. You didn't require further particulars, but seeing as it was for you to make the running on this application, the question surely was, why was no evidence available as to what actually happened to this file?
Well, my lord,
and that's not hypothetical. And there's a difference between saying, I don't need evidence of what's actually going on because it's so blindingly obvious, your Ukraine example, or this is a hypothetical situation. It's not a hypothetical situation. It's an actual situation for which the court, to my mind, needed evidence. And you gave general evidence to the judge, but not to the master about this particular aspect of that.
Well, look, I have made my submission
Yes,
hypothetical, and it's not going to benefit.
Well, I just want to make sure that we've, as it were, identified the issue that might arise as to whether this was or was not a hypothetical situation.
Well, perhaps I, in that case, ought to try once more, not by reference to the Ukraine, but by reference to a medical negligence situation. The effective criticism here is that steps were not taken until the 5th of May. That's the effective criticism. That's what the master was saying. When you look at that in a medical negligence context, you need to do two things. You need to ask, well, why were steps not taken earlier on than that? In my submission, this evidence does say, admittedly in general terms, steps were not taken because of the general dislocating effect. It would have been taken earlier. It's difficult for me to say how much earlier, but it would have happened earlier. That is, in my submission, properly to be described as hypothetical evidence, because it is saying if COVID had not occurred, I think what would have happened was the following.
The only way in which extension can be granted under 763 is where the claimant has taken all reasonable steps to comply. That's the wrong bit.
It is the wrong bit, but
Right, I was taking it off the application that had been made for the extension. But, which rule are we in?
Well, my lord, can I? I don't want to.
It's the wrong bit, but it all comes back
Well,
in.
where is it? The
7.62 rather than 7.63, my lord.
But you still end up back at the same.
That was why I was not wanting to mislead my lord.
Well, I'd gone from 2 to 3. They're both on the same page.
Well, yes. The reason why 3 is not strictly applicable is that there is a direct reference in the rules to a situation where we do not apply within the relevant time. That's not this case.
Sorry, that's after the end of the. Yes. That's my mistake.
Yes, but, and it's a point which my Lord Justice Coulson is picking up, when you go to the authorities, although plainly we can all read what the rules say, they nonetheless do say, well, you need to show a good reason. Now, I haven't gone through all of the authorities because, in truth, I don't actually criticise either the master for the judge of their summary. I've made some quibbles in my skeleton argument, but I'm not going to take up time of dealing with exactly the point that's been made. Sorry, my lord.
No, but so if we're not formally under, you're not formally under an obligation to show that you've taken all reasonable steps to comply with the rule. Is that the test, or is there some other test that you say?
It's not the sole test, because perhaps I could just take you to the skeleton. My skeleton.
Would you mind?
Can I just run this one by you, Mr. Stewart? Which is, you're dealing with medical negligence, which is close to my heart. In MedNeg, it's absolutely right that I suppose you could distill it down to 2 questions. One, was there negligence? 2, if there was, what difference to outcome did it make? So these sort of, I always used to call them factual causation issues. What would, if there hadn't been negligence, what would the outcome have been? Those are very familiar, and we talk about them as hypotheses, and I've got that. But that's in clin neg when you're looking at whether the baby would in fact have been damaged or whether the leg would in fact have been cut off or whatever. We're not dealing with that here. We're dealing with an exercise under the rules about whether time should have been extended. And my yardstick under 2 would be something like good reason. Not all reasonable steps, but some sort of reasonable steps were taken. Good reason. It's ultimately a discretionary exercise, isn't it? It's a bit of fact and a bit of discretion. So it's chalk and cheese. We're dealing with completely different things. It doesn't help very much to think about hypotheses in medical negligence.
Well, milady, don't accept that, because going back to the starting point in relation to all of this, we know as a fact that one has got a situation where, if you accept my submissions, the overwhelming likelihood is that however hard we paddled, so when one looks at good reason...
Sorry. I don't mean to interrupt you, but that's the point, isn't it? Is that you're inviting us to take an outcomes-driven view of our approach to CPR, whatever it is, 7.52.
Sorry, 5, yes.
And the case law suggests that it's not an outcomes-driven approach, it's a good reason-driven approach, whether or not, whatever might have happened in the end, what the person asking has to do, the appellant, the claimants, is show that there's a good reason why they couldn't serve in time. That's what we've got to look at.
Let me, if I may, challenge that proposition. Reason denotes causal effect. When you say, why did something happen, you are asking not just what the quality of the act was, but what the effect of that act was. In other words, I don't accept that by the word reason, you are getting rid of causation. That is why I started off by saying that you have got a certainty here, which is that unless everything had been done by the 15th of April, you know that this claim would not have been served in time. That's a certainty. That is therefore a reason why it was not served in time. Put it another way, suppose it had been the case that throughout the period it could not have been served in time, and suppose it was the case that we did not know that for some reason or other. When you say, why was it not served in time, the fact that we didn't know it doesn't mean that it is not a reason why it wasn't served in time. That's my first point. In other words, reason carries with it causal consequence. The second point is the point I was trying to make to your ladyship and to my Lord Justice Coulson a few minutes ago, which is that you are looking to the effects of COVID. COVID has 2 effects. One is specifically on the FPS. The second is the general dislocatory effect. To put it in language of loss of a chance, at the very least, the effects of COVID were such as to deny us the chance to complying with the rules. And one is also, although of course there is authority specifically on this question, standing back and looking at the overriding objective, interest of justice and so forth. In other words, one does have to take into account what difference would these things make. And that's why I've sought to emphasise the 2 kernels of the point which my Lord Justice Coulson was putting forward a preliminary view that was only one.
And so if you were wrong about the dislocating effect, and we put in general terms COVID to one side, your point would still hold good for the first point. It wouldn't matter why the FPS was closed. Might have had nothing to do with COVID. Might have been they couldn't get the staff, and so it was closed for however long. You would still say that's a complete answer, because I couldn't have served it by the 22nd of July. That's your certainty. That's your first point. So on that basis, my lady's question, if I may say so with respect, goes to the point that I think might arise on this appeal, this question of is there a good reason? And your submission is reason must be causative reason, so it must include a consideration of causation.
If I get driven to the abandonment of the second kernel,
I'm not seeking. I'm not seeking to do that. I'm just trying to get a path through.
That is the logical consequence of my submission, because I do say that even without what I've been referring to as the second kernel, I still succeed.
Yeah. Yeah. No, I'm not seeking to get.
No. But that
experience teaches me, Mr. Stewart, that it would be a fruitless task to persuade you to abandon an argument that you've outlined. But all I'm doing is hypothetically demonstrating that even if that were the case, your first point would still hold good. It is unaffected, effectively, by the second point.
Yes, I mean, one can take analogies. But if you prevent access to the site, then the fact that we might not have had the builders available doesn't make any difference as to the reason why the completion doesn't take. But probably analogies aren't particularly helpful.
Yeah, understand.
Right. You were going to. I was asking, in effect, for what's the best authority on what the test is under.
Yes, my lord. I was going to take you, if we may, to our main skeleton argument, which is at. Sorry,
I'm looking at around paragraph 14, or prior to that, you were citing various.
Sorry, my lord.
Cases.
I'm in the wrong bundle.
185.
Thank you. My lord, if your lordship would go to what we say we've set out at some length the passages from Mr. Justice Ramsey's decision in Imperial Cancer Research and O. Varrett, which is at tab 39. The useful point about these is that the learned judge, although it's a first instance decision, seeks to summarise Hash-Trudy and Hancock, which is a decision of this court. And if one looks at what he says...
I'm sorry, could you just give the reference? This is within your skeleton argument.
Yes, I'm looking at paragraph 39, my lord, in the core bundle on page 81.
Oh, I have a replacement skeleton argument and obviously an original one. Are you in the...
Have I given you the wrong reference? If I have, sorry? I'm sorry, try page 179, which would be...
169.
179.
179, thank you.
And if your lord, I was taking you to the summary of the relevant legal principles.
Yes. That was 185, I think.
And what we have there done is, first of all, accept that what the judge said was, broadly speaking, correct. But we drew particular attention to one of the Court of Appeal decisions, which is Cecil and Byatt.
Do you mind if, just to follow this through, you say 27 and 28 of the judge's treatment you were, for practical purposes, accepting is correct?
Yes, my lord. Would your lordship like to go to those?
Just want to see what he actually said.
Yes, of course. It's back in the sorry, my lord.
It's page 65 of the same bar. So he sets out list of Zara propositions.
And he took the propositions from Lord Justice Haddon Cave's decision, judgment, and he took that from a case called Al-Zara and Others, yes, which was 2019. And in particular, I anticipate that little 7 is of importance to what your lordship was asking me, and indeed to what her ladyship was asking me a few minutes ago.
Well, it's 6 and 7 hover over reasonable steps and good reason and those sort of matters. So the exercise is not to be performed merely by looking at as it were, the disembodied performance of the claimant, but it's the performance of the claimant in context with all the other factors.
I accept that. And I've made this submission already, but to be clear, reason imports causation as well, because why didn't you serve? Can I illustrate? One reason might be, despite the existence of COVID, we never had any intention of serving within the 6-month period, and we decided to serve thereafter. One could fairly say that the dominant reason there was because we didn't want to serve and COVID was irrelevant. Another situation would be, and I say it's this one, we were affected by COVID from the middle of the period. We wanted to serve. The reason why we didn't serve was because we couldn't, even though we didn't know about it, but that not knowing about it was influenced by the fact that the steps we took were slower. In other words, the causative consequences have to be looked at in the round.
I might have thought that the 7 points could be maybe compressed somewhat, but
different judges have tried.
Yes.
I'm sorry, I didn't mean that rudely,
but you're content. You were about to take us to.
Well, I was going to take you to Scotland because there's a bit in Lord Justice. Given that the judge based himself on what Lord Justice Haddon Cave was saying, there's a bit in Cecil and Byatt, which is an earlier Court of Appeal decision. In Lord Justice Ricks's decision, which shows in a sense the importance of causation, and perhaps given that, can I just, well, the relevant paragraph, or the relevant parts are those which we've underlined in paragraph 13.
Right, this is tab 2, is it?
This is in tab 17.
So these are in your skeleton.
These are my skeleton.
Where you've extracted the relevant bits of Cecil and Byatt.
Yes.
Yeah. Which is
and the proposition I'm
concerned with limitation.
Yes. The proposition that I'm doing there is seeking to identify the point as to what are exceptional circumstances. And for the reasons identified in the passages underlined, what I say you get out of those, 14 little 1 at the bottom of 187, in cases where a claim has become time barred, the claimant must establish there is a good reason for the extension which surmounts the prejudice which is or may be suffered by a defendant to be denied a limitation tense. A good reason is one which takes account of limitation, or which directly impacts on the limitation aspect of the problem. And then the two specific examples which Lord Justice Ricks gives are where the claimant has been prevented from serving in time or delayed in service for reasons which she does not bear responsibility. Now, those reasons in my submission are examples which are given effectively of good reasons. And in my submission, they're obviously right. I'd also say, for what it's worth, it probably wouldn't be the case that we'd be here at all if we were saying, look, specifically, I was all set to issue a letter on the 13th of March of 2020, but the relevant fee owner went ill, and so, in other words, if there was more flesh, if I can put it that way, on the bones of the evidence of Mr. Pulford, it would be very difficult in my submission to say why that wouldn't be a good reason. And so what one is really doing in saying that there isn't a good reason is that Mr. Pulford's general evidence is insufficient, notwithstanding the true extent of the true extent of COVID and the impact and so forth, which is set out. I've already given you my peroration, so I won't give it to you twice. I'm also conscious that I've done that which advocates should not do.
You've been obstructed.
I'm not going to make any observations on the causal links between the time and so forth. But unless...
Just I wanted to ask you, were you content with the judge's summary of the principles? I know you took them from Lord Justice Haddon Cave in the Zara case. I wasn't sure quite where number 7 had come from, actually. And I wasn't, maybe I just hadn't looked hard enough, but I think we can agree the strictness with which the jurisdiction is applied, I'm on page 66 of the core bundle, is of general application. I wasn't sure about the next passage. Save in exceptional cases, a good reason is required to extend time. Is that right, or is it actually, or it's that you need a good reason in any event, but if time has expired and your time barred, then you need to look at exceptional circumstances?
I think actually on observation, your ladyship's observation is probably correct. In other words, a good reason, if you crossed out a good reason is required to extend, if you crossed out save in exceptional circumstances, then it would be correct to say a good reason is required to extend time. The general regime is a strict one, that's true.
That's all fine.
This will be particularly the case where limitation involved. That is all cases.
I couldn't,
I think I'd better just
think
check
about
whether
that?
or not saving the exceptional circumstances comes from somewhere else.
Yeah, being a sad soul, I did track, I could find the origin of all the other propositions, but 7 I couldn't quite track down. It sort of comes from Cecil and Bayard. But I had in mind that the exceptionality bit goes with those cases where, which would apply in this case,
yes,
you have exceeded the limitation period.
I think, my lady, that may well be right. I mean, the point is, nonetheless, can fairly be taken against me that we issued 2 days before the end of the limitation period and so forth. But I will, if I may, check that.
I just get a bit twitchy when we have propositions that might, that will be asked to agree with or not agree with. We want to make sure they're absolutely right. Can I leave that one with you,
yes,
please?
Thank you very much. Yes, Mr.
Could I begin by focusing on the evidence in this case? And I'd like to take as my starting point a short passage from the decision of Mr. Justice Butcher in S.A.
I'm sorry, this is very discourteous of me, but just at the moment we've been thinking about the legal test, and we have that, as it were, in the forefront of our minds. You don't have to tell us what you're going to tell us, but are you going to tell us something about the legal test?
Yes, indeed.
Right. Is later the moment, or is now the moment for you to...
If you prefer me to deal with it now...
Well, speaking personally, I would, while we have
it's fresh in your mind.
The points fresh in our minds.
The distinction is between Order 7.62 and 7.63.
I've got that.
And the distinction is very simply that if the application is made under 7.63, that's to say after the limitation, after the time for service has already expired, the court has no jurisdiction, no discretion, unless a good reason is shown. And the conditions specified in 7.63 are satisfied.
It's all reasonable steps, isn't it?
All reasonable steps, yes. If the application is under 7.62, the court does have a discretion, but the case law shows that it is still necessary to show a good reason. And that distinction is explained in Cecil and Bayard, I think at paragraph 48. I'll come to that later if I may, if that's still a live issue. But that's the essence of the difference. It's simply whether
that's got nothing to do with this case. That's got nothing to do with this case, because we know we're under 7.62.
Exactly. We're under 7.62, and the court still needs a good reason.
Yeah.
So,
What do you say about?
so-
Sorry.
yeah.
What do you say about the question of causation as a legal test?
Oh, well, that's very simple, my lord. What my learned friend posits is the situation where, in his extreme example, the lockdown occurs right at the outset and the party knows about it. Well, consider the position of two potential claimants, both with that same starting point. Neither of them knows how long lockdown is going to last. So they are both under the same obligation to proceed and process their application expeditiously, having left everything to the last moment before issuing. When they both arrive 6 months later at the point of making an application to the court for an extension of time, one of them is able to say, well, I did everything I could, I was ready, these are the steps I took, and these are the obstacles I encountered, and for that reason I still haven't made it. The other says, well, I did absolutely nothing, but it wouldn't have made any difference. Even if I'd taken all reasonable steps, I'd have ended up in the same position as the other applicant, and it would have made no difference. The jurisdiction the court is being invited to exercise in this case is one that depends on forgiving a deserving applicant who's done everything that they reasonably could. It does not apply equally to the applicant who sat on his hands and says, well, it would have made no difference. You couldn't have known that it was going to make no difference because you didn't know how long these conditions were going to last. So the causation point is simply a bad one. The jurisdiction that is in question here isn't one that says, well, it makes no difference whether you acted expeditiously or not. We'd all be in the same position. It's one that looks specifically at the reasons why you were prevented from serving. And at this point, I would like to go back to where I started.
Before you do, the judge's summary, paragraph 28, subject to the point that my lady raised at the end, do you take any great issue with that?
No, I don't.
You probably remember if you did. So
Yeah.
at the moment, it's not the judge's self-direction that is being thought of. Okay.
Sorry, you finished that by saying it looks at the reasons why you were prevented from serving.
Yes.
Isn't that causation?
It is causation, but it's...
Well, you said the jurisdiction is not, it does not involve looking at causation.
Well, it involves looking at why you did nothing. It is a jurisdiction which enables the court to forgive an assiduous applicant who's done everything in his power to get his case in order, and it does not apply to someone who has sat on his hands and then turns around and says, well, I got lucky, it wouldn't have made any difference.
I've just noted your submission as being that it's merit-based.
It is merit-based.
Right? So the idea is, on your case, you're looking for a good reason, not any old reason, but a good reason, one that is meritorious in the context of the particular case. Something like that.
And at this point, I would like to go to the evidence and the reasons that they actually give for having, that resulted in them getting to the situation that we are here, we're at today. And I would like to start by picking up Lord Justice Jackson's point about the kind of evidence the court expects in a case of this kind. And it's set out very, very neatly in the passage in STA and OFY at tab 10 of the authorities bundle. And I'd like to take you to it because I actually slightly misquoted it in my supplementary skeleton. Page 152 of the authorities bundle.
Sorry, page?
Page 152. And this is specifically dealing with the way in which COVID-19 is said to have affected the party's ability to serve. And it says, what is required and is regularly provided is a detailed explanation of the way in which the pandemic has affected particular people or particular processes. Such evidence is lacking here. Now, at this point, I'd like to take you to the evidence that was actually before the court, because it's not simply that the evidence is entirely lacking in this case, it's that the evidence is inconsistent with what is now being said. And the starting point is the first witness statement of Mr. Pulford, which is in the supplementary bundle at tab 15. This is Pulford 1. It's a very short statement. This is the evidence that was before the Master on the very first application. And the reason that is given here for the need for an extension of time is the submission that the parties believed, or that the claimants believed, that there were meaningful negotiations. And that is why they took no action
Where are you reading from, as it were, or summarising from?
well, under background, it sets out the background. Then at paragraph 9, it begins, whilst the parties continued to seek to negotiate an acceptable agreement, given that the limitation period for the Nike, that's another action, was to end on the 13th of May. The parties into a standstill agreement.
Whenever I see the word standstill agreement, my heart hits my boots. I think it's probably because we only ever see the ones that go wrong.
Yes.
But there are an awful lot of them.
There are.
I think I once did a judgment in which I said something like that. It would be a very good thing if they were made illegal and subject to penal consequences if people tried to enter into them. They simply put off people deciding when they need to do something, and then very often, not a criticism of either side, it just so happens there's a misunderstanding, and then the court has to sort out the outcome.
Well, my lord, there was no standstill agreement in this case.
No, I understand that.
What was happening was that there was a completely separate action in which there had been a standstill agreement negotiated.
Yes, this is why I was asking about this, because when we get to paragraph 11, we get to these proceedings. And the standstill agreement in relation to the other matter was prior to that, and indeed it was because of the inability to negotiate one in relation to Alexander that the claim was issued at all.
Yes.
So I'm really looking to see what it doesn't seem to be saying we didn't serve because of we were hoping for something from the
Paragraph
response.
11. The last sentence.
Well, it does. Paragraph 10, the limitation period for the head of the Alexander was to expire on the 24th of January. In advance of the limitation period, Mr. Lamati negotiated directly with Phoenix about the possibility of amending the standstill agreement with a view to broadening its scope to encompass the head of Alexander, in addition to the Nike.
But anyhow, that came to nothing.
That came to nothing.
Yes, but nevertheless, hope springs eternal. Paragraph 11.
Well, what the Master found and the judge agreed with is that the fact that the solicitors refused point blank to extend the standstill agreement to encompass the to encompass the Alexander, was a pretty clear indication that they intended to take the limitation point if they could.
Yes.
There was no basis for
But at the moment, I'm only anxious to gain from this what you say the evidence showed in the first statement, which was before the master, for the ex parte order, the reason that was being given for the extension was.
Well,
and can we pick those out just before we?
Well, it's the next. I don't want to read the whole.
No. So what reasons do you say, and what paragraphs are they in?
At paragraph 11.
Yes, right.
The end.
Hopeful for settlement.
They were hopeful of settlement.
Right.
And it's really that takes us from the 22nd of January, which was the letter, to the 7th of May, which was the next letter.
Exactly.
Yes.
And there isn't a word of explanation other than the hope or expectation of a negotiated settlement. That is the only reason given, and that nearly 4-month period is completely unaccounted for. There is no mention of disruption caused by COVID. The only reference to the problems of COVID start at paragraph 15. Which relate to later events from the 22nd of May onwards. There's still nothing about any disruption or inconvenience being caused to Vincent Mason's.
Right. So your timeline then is that there's 3.5 months when nothing happens, in hope that the case is going to settle. But there's then a period where you don't, obviously the judges thought this was quite disobliging, but you don't answer letters.
And 2 letters that go unanswered within 2 weeks of the final cut-off point for service in the jurisdiction.
Yes. And then that runs out on the 22nd of May.
Yes.
So, by these means, you say they've left themselves 2 months to serve.
Yes.
And that's paragraph 14, isn't it, where that's pretty much, I took from paragraph 14, it was a very clear indication that once the door to service within the jurisdiction closed in May 2020, it was then necessary for the claimants to take steps to serve out of the jurisdiction, so the concentration then shifts to how we're going to get service in Switzerland.
Yeah. And even then, they're taking things at a very leisurely pace. One of the curiosities, I looked for this, but there's no evidence before the court as to the date on which counsel was instructed to draft the particulars of claim. All that's said is that on the, I think, 7th of August, so long after the expiry of the second cut-off date, the claim form, the particulars of claim were amended very slightly and reissued. But there's no date on.
Do they have to be served with the claim?
It didn't. They. I'm not sure. I don't. Normally they wouldn't. Normally you could serve the claim form and serve the particulars of claim 14 days afterwards.
That's right. You can seek an extension at that stage, can't you, if you need it?
Yes.
But I mean, if you got in under the wire and served your claim form,
yes,
but it was not accompanied by a particulars of claim, that would not invalidate the process.
No, it wouldn't.
Right. So to that extent, whether counsel is or isn't drafting particulars of claim and when is not first important.
It's a surprising omission, though, that if you know you've already left the issue until 2 days before the expiry of the primary limitation period, the cases are unanimous that you are under an obligation to progress things quickly.
Right. Well, let's suppose you're correct and that they've spent the first 4 months without making any progress whatever, and they then got 2 months, which is about what it takes to serve in Switzerland, is left, but the door is, as it happens when they go to it, shut upon them because of the foreign process section. So what's the analysis then?
Well, they still don't act very quickly.
We've got until the 22nd of July, and we're looking at paragraph 15 of this statement, aren't we? To what happened internally, which then took up another month.
I'm sorry, my lord.
We're looking at the statement still. I'm just trying to see what the master had in front of him at the beginning.
So where your point is, there's no reference to COVID other than the passing reference in 15. And then
That's right. And the only explanation given for the 4 months is the belief that there is going to be a negotiated.
Yeah, but we understand that.
Well, the inference from that isn't that they were prevented from taking the steps that they would otherwise have taken because of disruption, because the pubs were shut, or because there were problems with homeschooling or anything of that sort. It was that it was a deliberate decision to wait in the expectation, firstly, that there would be a negotiated settlement, and secondly, and this was another point on which the master and the judge both held there was no basis, that Boys Turner would accept service in the jurisdiction.
Right, but I was just trying to move forward into the 5th month, because in the 5th month it appears that was very largely spent in internal preparation.
Well, even then things move very slowly. So we've got from the 7th of May until the 23rd of June. From the 7th of May till the 22nd, they still haven't even considered what the requirements are for service out of the jurisdiction. My learned friend says in his skeleton argument for this appeal, he says that in relation to the period after the 7th of May, there's no substantive criticism of the conduct of the claimants. That's simply not the case. So you've got, 2 weeks after that before they even consider the requirements for service abroad. On the 22nd of May, they instruct, they're told that they need to translate documents, and on the 3rd of June, it's another 12 days, I think they instruct La Live to advise them in Switzerland. This is in Tapper 1.
Right, we'll take that as read. Yes? And they get some advice back on the 15th of June.
There's then a further nearly 2 weeks, from the 3rd of June to the 16th of June, before they contact the FPS for the first time. And when they do, the FPS responds the next day.
Although somewhat oddly, the FPS don't say we're closed.
No, they don't. And then there's another day from the 16th.
Your point is what? That as at the 16th of June, that's the first time they contact the FPS. So if we take it that the usual period is 2 months, then even if there'd been no COVID, they'd still have needed an extension.
Oh, yes. And their own evidence, Mr. Tapper's evidence is clear on this, that it's, when they discover on the 23rd of June that the FPS has suspended its services, they already started preparing their application for an extension of time. That's at paragraph 11. whilst the preparation of the claimant's first application of the 26th of June for an extension of time was already underway at this stage.
Sorry, what page is that?
That's at page 209 of the supplementary bundle.
That's Mr. Tapper.
That's Mr. Tapper, yes. And he says, this is repeated in their skeleton, and I confess I don't understand it. He says, although it was well underway, the confirmation of the suspension of the FPS was a critical factor in making the claimant's application. Well, they already needed to make the application. They'd already started doing so.
So, staying with the first statement at the moment, which was the one in support of the ex parte application.
That was the ex parte.
There is no mention of either COVID as being the reason or of the section being closed.
That's right.
Right. So when we now get the contested application statement.
Pulford 2, that's at tab 23. And at page 87, starting at paragraph 25, you have the heading Justification for Extension. And here again...
Could you give that reference again, please?
It's tab 23 is the start of the witness statement.
Right, so we're now moving to... Right, this was...
And page 87, paragraph 25, Justification for Extension. And about 2.5 pages of that takes you up to paragraph 32.
Yeah.
Paragraph 28, he says it was unfair to criticise the claimants for doing nothing until the 7th of May because the claimants were still hopeful that the parties would be able to negotiate. Paragraph 29, this is where he makes the point that claimants have not yet instructed counsel to prepare a statement of claim. Paragraph 30, he says there was no reason to suspect that Boyce Turner would not accept service. Paragraph 31, again he refers to the suspension of FPS service. But of course, they didn't know about that until the 23rd of June, so that wasn't part of the reason. And then the remaining paragraphs deal with the completely separate claim in relation to the Nike. So those are the reasons they actually gave. And if you turn to what the learned judge said in relation to those reasons, this is at tab 7 of the core bundle.
paragraph?
Paragraph 32. So paragraph 31, starting off. The Master referred to the procedure involving the FPS and the suspension of that service from the 16th of May. He noted the argument of the claimants that they had only an abbreviated time prior to the suspension, so that with hindsight, it could be said that an extension of time was inevitable. He further recorded the concession of the claimants that they'd taken no steps prior to May 2020, but that there were good reasons to justify this, namely the assumption that the defendant's company solicitors would accept service within the jurisdiction. The Master then turned to consider this question: did the claimants take all reasonable steps to comply with the rules, such as to establish good reason not to have served the defendant company by the 22nd of July? And I'm just pausing. I accept that it's not necessary for them to have taken all reasonable steps, but it was at the very least necessary for them to take some reasonable steps, or some steps. He referred to the need to apply to the principles which emerged from the authorities, i.e. the authorities to which I've already referred. He took into account the following factors: the claim was issued 2 days prior to the expiry of the limitation period, the importance of the expiry of the limitation being considerable, the claim being sizable, which meant that an enhanced degree of care and conduct was necessary, public health emergency meant that nothing should be left to chance. Claimants took an over-optimistic view of the approach that would be taken by the defendant company, such optimism not being justified by what was known of the company's attitude to a proposed standstill agreement. The claimants took no active steps in the period between the issue of the claim and early May 2020. And then that's summarising the Master's view. The judge, later in paragraph 42, concurs with that. If I can pick it up, well, paragraph 42, the difficulties with the FPS did not begin until the middle of March, and the service was not suspended until the middle of April. The claimants had issued their claim form days before the expiry of the limitation period. Therefore, it was incumbent on them to act promptly. It's quite correct, Mr. Stewart, to state that the claimants had 6 months in which to serve the claim form out of the jurisdiction. It's necessary to emphasise that the rule permits 6 months to serve out of the jurisdiction.
Yes, we've read this.
I'm sorry, would you prefer to read that?
Well, is it the passages we've just been looking at a moment ago? Well, at the beginning of paragraph 42, which we've read a number of times.
It's simply that the judge endorses the Master's view that the claimants took an optimistic view of the attitude of the defendant's company solicitors to accepting service, which was wholly unwarranted given the history of the case in the period preceding the issue of the claim form. The only evidence that there were any negotiations was hearsay evidence.
Well, we've read that and we understand that, and that's not at the forefront of Mr. Stewart's submissions.
No.
Mr. Cooper, can I ask you about a passage which Mr. Stewart relies on just in the middle there? Had they done so, the problems with the FPS about which they knew nothing at all until late June 2020 could have been overcome. Well, what do you say about that? Do you say that that is either here nor there? Does that matter to the analysis?
Well, it doesn't. They might have been overcome.
How?
Well, it's possible that they would have had everything ready to serve before the FPS suspended its service. That is a possibility. They had the best part of 3 months, I think.
Yeah.
It's
not a foregone conclusion that they would not have been able to serve.
Anyway? I'm picking away at the legal test that I think you and I discussed earlier. Does it matter anyway? And doesn't it go back to the point about whether you're looking at an outcome or whether you're looking at a reason? Does it matter whether they would or wouldn't have got there?
It doesn't, no. What they have to show is that they took reasonable steps.
No, they don't.
point-
That's not the right test. Reasonable steps is 763.
So that they have a
No.
good reason.
It's just good reason.
No.
In accordance with the overriding objective.
Yes, 763 says the court only has jurisdiction if they have taken all reasonable steps.
And all reasonable steps, the only place where all reasonable steps is referred to. We're not under 763, so we need to put to one side all reasonable steps. The question is good reason, and that's to be exercised in accordance with all the authorities we've looked at.
Yes, but the authorities look at good reason in terms of what these applicants have actually done. I mean, I go back to the point that...
The point Mr. Stewart is making is that in order to get this served, it would have had to be served before the service was suspended in the middle of April, because anything after that was fated.
Yes.
So what's your response to that?
Well, my response is that if they had taken reasonable steps and had been in a position to serve within the 6 months, but for the suspension, then they would have a good argument before this court for saying
Let's suppose
time should be extended.
let's suppose they start off in January and they try to negotiate for a month, which might not be regarded as being open to any criticism, to prevent the proceedings starting. And then they do their homework about how they're going to have to go about serving you outside the jurisdiction, in particular in Switzerland, and thereby we get to February-March time, and at that point they press the start button and get on with the process. Can it be said that they would have served in time when the bar went up in the middle of April?
Well, no, my lord, but that's not my argument. First,
I'm asking how you meet Mr. Stewart's argument.
Can I pick that apart?
Yes.
First of all, the authorities say that the fact that you are negotiating is not a reason for not starting your preparations.
No, but you might have a series of not very good reasons.
Well,
But you would still get over the line if the office had not shut in the middle of April, because you have 6 months. So why is one to leave out of account, which is what in fact has happened here, the fact that the foreign process section was closed?
well, one leaves it out of account because these claimants sat on their hands. They would have been seeking an application for an extension of time, even if the FPS had been operating a full service throughout this period. Why should they be in a better position? Because unbeknownst to them, it had in fact been suspended. Their duty, their obligation, and the authorities are quite clear on this, their obligation, having left matters until 2 days before the expiry limitation period, are to progress their claim. And if they don't do so, they can't expect the court to look on their application with any sympathy. They don't know. I mean, even if they had known that the FPS service had been suspended, they couldn't have known for how long. It might have reopened before the expiry of the 6 months. Their duty was to be ready to take advantage of it as soon as it reopened. And so the fact that there is no explanation for them doing anything for the first 4 months, or that the explanation given has been held to be a bad one, means that they come before the court today asking for what is effectively an indulgence in circumstances where the authorities say the court will indulge you if you have acted reasonably, if you have complied with your duties. Because otherwise, we're in precisely the situation that your lordship put to my learned friend earlier this morning, of saying COVID amounts to complete suspension for everyone.
Putting it another way, it couldn't take anybody by surprise that you need to allow 2 months for foreign service.
No.
Because apart from anything else, that's what you get on top of domestic service, and one can see why serving in Switzerland might take you that length of time. So you point to the fact that they weren't ready at 4 months. Had they been ready at 4 months and then turned up and either expectedly or unsurprisingly, or to their surprise, found that the office was closed, then you might have great difficulty in resisting an extension.
Yes.
But they weren't ready at the time when they would have needed to be ready in any world, whether it's a COVID world or a non-COVID world, an office open world or an office closed world.
Precisely.
And so that comes back to the submission that they would have needed an extension of time even if the FPS had not been closed.
Well,
because as at the 22nd of June, they were only just working out that they needed to use the FPS to serve their proceedings abroad. And if the average time is 2 months, then any sensible solicitor would be seeking an extension because they would be absolutely right on the line.
well, yes, if had they done their preparation, I mean, I'm not conceding that if they had got their skates on as soon as they had issued proceedings, they would necessarily have missed the deadline for service.
Because they could have done it before the 15th of April.
Because they could have done it before the 15th.
I understand that
Yes.
submission, but I'm just picking up your submission that they would have needed an extension of time even if the FPS had not been suspended. And that must be because by the time they woke up to the FPS and by the time they woke up to the need to use them and how long these things would take, we're at the 22nd of June.
Yes, they would have needed one, but what I don't admit, what I don't accept is that they would have had a reasonable case for getting one.
Well, that's a separate point.
It's a separate point.
They would have needed the point. Your point that they would have needed one is effectively an answer. You would submit as an answer, even if you're wrong and causation is relevant. You'd say that's an answer to Mr. Stewart.
Yes.
That even if you look at causation, he says, well, I'd have always needed an extension because it was closed. You say you'd have always needed an extension anyway.
Well, I'm not accepting Mr. Stewart's characterisation of what is meant by causation.
Well, I understand that, but if you're wrong about that,
If I'm wrong about
if you're wrong about that, and the legal test, looking at the overriding objective, doesn't rule out causation, then you say that's the answer. He would have always needed an extension.
But the risk of repeating myself, if that is a good argument, then it means it's a good argument, irrespective of what steps the claimants have actually themselves taken. The claimant who had done absolutely nothing up till for the whole of those 6 months would be equally entitled to say, well, it would have made no difference if I'd done what I was supposed to.
Keeping with the closure of the FPS, which was for what, 3 months?
3 months in a week,
3 months and counting. In order to be able to run that argument, you have to be able to show that you would have had at least a substantial chance of being able to comply if it had been open. No, I've got it the wrong way around.
With respect, I don't think that's right. I think what you need to show going back to this point that you don't know how long the suspension is going to take at the beginning, that you have done everything the court said, the authorities say, you are supposed to do in the meanwhile.
At the point where it became necessary for you to seek an extension.
Yes.
And if you hadn't done it by that stage, you can't rely on the adventitious fact that the office was closed to bail you out.
No. That must be right, because otherwise...
It's a de facto extension of the period for service for everybody.
It is, yeah. Can I just, while I remember, pick up one point? Mr. Stewart has been repeating this date, the 16th of March, and it's sort of got sunk in as being a significant date. Can I ask you just to look at his skeleton argument at page 182 of the core bundle?
Comes from Mr. Baker's evidence, that thing.
This is the date of the lockdown. Do you have that, page 182? Paragraph 7.2. He says on the 20th of March, the Prime Minister ordered all cafes, pubs and restaurants to close on the 23rd of March. And on the 23rd of March, he made a televised announcement that there would be a UK-wide national lockdown with effect on the 26th of March. Footnote, before the Master, the date for the UK lockdown was erroneously given as the 16th of March, based on Baker. And I draw that point simply because he's given himself an extra 10 days.
Yes, I'm looking at the time. How are we getting on?
I think I should be finished by 1 o'clock.
Well, there'll be
Some
time for an answer. Well, I think we've grasped the point, and we have the skeleton argument. So, what area do you want to cover?
Well, it's covered at some length in both the skeleton arguments, so I'm relying on the court to read and look at the authorities. But what I say is that the authorities make it absolutely plain that in deciding whether or not to exercise this discretion under 7.62, the court looks at what this claimant has actually done. And for the claimant to say, well, I didn't do anything for a bad reason, I deliberately withheld taking any further steps until 2 weeks before the end of the expiry of the first 4 months, and then, to my great surprise, discovered I had to serve outside the jurisdiction. Those are relevant factors for the court to take into account in deciding whether to indulge an applicant who has been unfortunate through no fault of his own. Perhaps it's worth looking at just one passage in the authorities that makes this point. It's repeated in many places. Perhaps the clearest statement, or the most recent, is in the Alzara case, which is at tab 1. I could pick it up at page 18, where Justice Haddon Cave goes through the authorities. Starting with Hastrudi and Hancock. The following principles can be derived from the judgment of the court given by Lord Justice Dyson. 1, there's no threshold requirement or implied condition that a good reason must be shown for a failure to serve within a specific period before the court can exercise its power to extend time under 7.6. The court's power is simply has to be exercised in accordance with the overriding objective. As a matter of common sense, it is not possible to deal with an application for an extension of time under CPR 7.62 justly without knowing why the claimant has failed to serve the claim form within the specified period. For a more calibrated approach, that's to say the weaker the reason, the more likely the court is to refuse to grant an extension. This is looking at the reason subjectively. If the reason why the claimant has not served the claim form within the specified period is that he or his legal representative simply overlooked the matter, that will be a strong reason for the court refusing to grant an extension of time for service. Now that must be the case even if there had been some extraneous reason unknown to the solicitor that would have prevented him if he hadn't been negligent. It's not it's not that the court will exercise its jurisdiction to overlook the negligence of a solicitor because by accident there was another reason that would have prevented him. Wolf reforms are aimed to introduce a more disciplined approach to the conduct of litigation by insisting that time limits are adhered to unless there is a good reason for departure. 7 says, there's, quoting Venus and Marks and Spencer's, there's nothing unjust with the system that imposes a limitation period. In summary, discretion should be exercised in accordance with the overriding objective. And here we come, next paragraph to the passage I really want to emphasize. Quoting from Professor Zuckerman on civil procedure, and this is a passage which is quoted in a number of the other decisions. For it is only fair to ask whether the claimant is seeking the court's help to overcome a genuine problem that he has encountered in carrying out service, or whether he is seeking relief from the consequences of his own neglect. A claimant who has experienced difficulty should normally be entitled to the court's help, but an applicant who has merely left service too late is not entitled to as much consideration. Whether the limitation period has expired is also of considerable importance. If an extension is sought beyond 4 months after the expiry of the limitation period, the claimant is effectively asking the court to disturb a defendant who is by now entitled to assume that his rights can no longer be disputed. And my submission, my lord, that focuses on the subjective reasons given by a particular applicant on the basis of which he asks the court to relieve him of the consequences of the difficulties that he has encountered. And it means that 2 applicants might find themselves on the same day making the same application, one of whom has done everything he could reasonably be expected to do, and the other of whom was either negligent or deliberately, for a bad reason, decided to do nothing. The court will look on their applications differently.
Yes.
I just want to say a few more points in response to my learned friend's skeleton argument. He says that the master's judgment and the judge adopting it suggests that the claimant should somehow have foreseen the pandemic and acted differently. That is not correct. What they say is, and my submission is, that the claimants should have pursued their claim in any event, just as they couldn't foresee that the FPS would suspend services, so they couldn't foresee when it would reopen. And their duty was to be ready as soon as it was open. He says there's no substantial relevant dispute in relation to the periods after the 7th of May. When I've dealt with that, there certainly are criticisms. It's certainly true that by the time we get to the 23rd of June, they realise the mess they're in and start taking things a bit more seriously. But nevertheless, there are several weeks of unexplained delay after the 7th of May. And what it all comes down to is the claimants effectively saying it doesn't make any difference what we did, what we would have done. We would have needed to make an application anyway. That may or may not be true, but the court's approach to whether or not to grant an extension is not dependent solely on that. It's a form of, it's a jurisdiction which is open to the court to exercise in favour of a deserving claimant, but to withhold in the case of an undeserving claimant. And that's the long of the short of the argument.
Thank you, Mr. Gibbon. Yes.
My Lords, 3 points. The first not being by way of reply, but picking up the matter which my lady put forward, and with thanks to my learned junior. The judge's summary at paragraph 28 bases itself on Lord Justice Haddon Cave's judgment in Al-Zara, Core Bundle, page 66. However, the summary in the judge's paragraph 28(7) looks more like what Lord Justice Ricks said at paragraph 55, Authorities Bundle, page 55. Sorry, paragraph 90, page 55. Although Lord Justice Ricks referred to exceptional circumstances, not exceptional cases.
Okay.
Alternatively...
And that's Lord Justice Ricks in Cecil and Byatt.
It is indeed, my Lord.
Yeah.
Alternatively, it might be that the judge is going back to Lord Justice Haddon Cave and Cecil and Byatt, paragraph 52, subparagraph 3, Authorities, page 20, which cites Stanley Burnton, Lord Justice Stanley Burnton in Cecil and Byatt at 55, Authorities, page 44, although again that refers to exceptional circumstances, not exceptional cases. That looks as if that's the line through.
Well, thank you very much, and thanks to your junior, Mr. Harris, as well, for doing that. I'll track that through. It was just the context in which exceptional circumstances arise that I was a little bit fussed by, but I'll try and drive that nail home.
My lady, if I may say so, having focused rather more closely on the point, I agree, if I may respectfully do so, with your ladyship's hesitation. 3 very short points by way of reply. The first is in relation to the decision of Mr. Justice Butcher in the ATA case, which is the last, sorry, STA and OFY case, which is the tab 10 of the bundle of authorities. What this case was was an application to extend time for challenging an arbitration award in circumstances where the relevant, first of all, the starting date is a 28-day period, which is known to be a very short period for statutory reasons. Secondly, in circumstances where the relevant dates are all in 2021. In other words, what the judge is doing in the passage set out is saying, my paraphrase, not his words, we all now are learning to live with COVID. We understand where it is that you go in relation.
It was a known factor.
It's a known factor. If you're going to say you can't get evidence because of X and Y, you have to come back and say, look, the minister who's dealing with this matter is ill, there's no other method for doing it, it's specific evidence. Completely different, I say, from this case where the hurricane has come out of the blue materially during the relevant period. No one has seen anything like COVID before. That also ties in to my second point by way of response. My learned friend is critical of the solicitors. He's referred several times to them being negligent and so on and so forth. It is very difficult indeed, in my submission, to underestimate the enormous impact of COVID specifically in March and through until May of 2020. We now have all had to live with the wretched disease for now pretty well exactly 2 years. And of course, human beings being what they are have learnt to cope with it. But it did not. When it's referred to as the greatest peacetime emergency, that's not hyperbole. It has an overall impact. And just briefly going back to an important submission of mine, looking at what did happen as a proxy for what would have happened is dangerous for the reasons I gave. So that's my second point. Third point by way of response. My learned friend says that it is in issue as to the steps which were taken after the 7th of May. Neither the master nor the judge thought that there was nothing in their judgments criticising the steps which were taken after that stage. It is true that my learned friend has been critical in relation to those matters, but they are not part of the judgments which are before you. And last point, in relation to Zuckerman, importance of a defendant not being disturbed who is entitled to believe that, as it were, his matters have come to rest. Not very applicable to this case. This is a defendant who, as he's entitled to, is sitting there knowing that the claimant wants to press a claim against him, but is thinking, aha, COVID, it's going to be jolly difficult. Now, in those circumstances, if you look at the overriding objective and say, is it really just that in circumstances where there has been actual impeding, and where I say, rightly or wrongly, that's a matter for your lordships to decide, that the, as it were, as happened situation is not the alternative situation, is the justice that a defendant who would have been served later, unless he'd accepted voluntarily in any event, should not be served really encompassed by what Professor Zuckerman says?
Well, Mr. Stewart, if it's any assistance, I always think that passage, with great respect to Professor Zuckerman, goes outside the scope and indeed the purpose of the CPR. You can't end up looking at what defendants or indeed claimants, depending on which way round it is, were entitled to believe in terms of their underlying rights. That's not a part of Part 7.
I gratefully accept and endorse your lordship's observation as my submission. My lords, my lady, unless there's anything else, those are my submissions by way of response.
No. Thank you very much indeed. Very well. Well, obviously we'll think about this and let you have our decision in due course in the usual way, and following the corrections to our draft judgments, you please agree in order, and the hand down we won't need to trouble you because it will almost certainly be electronic. Thank you both, and thank you all very much indeed.
All right.